Hello, and welcome back to the deep dive. If you're currently wading through contract law, this deep dive is, well, it's pretty essential. We're tackling one of those big pillars, the intention to create legal relations.
It absolutely is. A contract isn't just offer, acceptance, consideration. You can tick all those boxes, but
Yeah.
if the parties didn't actually intend for their agreement to be legally binding, well, the law usually won't step in to enforce it.
And that's the fascinating bit, isn't it? Where's that line? So today, we're really zooming in on agreements made in, let's say, social or domestic settings, family, friends, that sort of thing. Our mission, using the materials you shared, is to unpack how courts figure out if these often, informal chats actually become enforceable contracts.
Exactly. It's all about separating a casual promise, maybe something said over dinner, from an agreement that has real legal teeth.
Okay, let's get into it. When we're talking agreements between family members or people in domestic relationships, what's the general starting point for the courts? What's their initial assumption?
Well, the starting point is a pretty strong legal presumption. Uh, the courts generally presume that parties in these kinds of settings, family, social teams, they don't intend to create legal relations.
Hmm.
They tend to see these as, private arrangements, not business deals.
So the default is it's just a family matter, not a contract. That can feel a bit odd sometimes, can it? Like, what if it's a serious promise?
It can seem odd, yeah, but there's a sort of policy reason behind it. It reflects this longstanding idea that courts shouldn't really get tangled up in every single promise made within a family.
Hmm.
Imagine the courts dealing with disputes over, I don't know, pocket money or who promised to do the washing up. It's partly about keeping purely domestic stuff out of the legal system unless it's clearly meant to be there.
Right, avoiding getting bogged down. And the classic case everyone learns, the one that really illustrates this presumption, is Balfour and Balfour. Could you walk us through that one?
Ah, yes. Balfour and Balfour, foundational, really. So you had a husband and wife. The husband worked in Ceylon, Sri Lanka now, of course. They were on leave in England, but the wife became too ill to go back with him. So he promised her, verbally, £30 a month until she was well enough to rejoin him. Later, the relationship soured. He stopped the payments, and she sued.
Okay, so a promise between husband and wife, what did the court decide?
The court said, nope, no binding contract here. They viewed the agreement as purely a domestic arrangement. Crucially, it was made when their relationship was, as the court described it, harmonious. They reasoned that the parties simply hadn't intended this kind of informal spousal promise to be legally enforceable. Lord Atkin's judgment is famous here, saying these agreements are outside the realm of contracts altogether.
That makes sense in that context, doesn't it?
Yeah.
A married couple making a temporary plan while she recovers, it wasn't like negotiating a business deal.
Precisely. And you see this same thinking pop up in other situations too, not just spouses. Whenever the background is mainly social or domestic, the materials mentioned De Cruz Andrea and Guangzhou Health Products reinforcing this general idea.
Okay, so the starting point is no intention, no contract in these family or social deals. But you said it's a presumption. Does that mean it's not an absolute rule? It can be challenged.
Exactly right. It's just a starting point, a presumption. It's not conclusive. If you can bring forward enough evidence to show that actually these specific parties did intend to be legally bound, even though they were family or friends, then yeah, you can rebut that presumption. And the agreement can be a binding contract.
Ah, okay. And the materials you gave us have some really good examples where courts found exactly that, where the presumption was rebutted. You mentioned Merritt and Merritt, Wakeling and Ripley, Simpkins and Pays. Let's take Merritt and Merritt first. How is that different from Balfour?
Merit, and Merit's a brilliant contrast. Again, husband and wife. But, and this is the crucial difference, they were separated when they made the agreement. They were sorting things out, essentially. The husband wrote down and signed a note saying he'd pay her a monthly amount, and once she'd used that money to pay off the mortgage on their house, he'd transfer his share of the house to her name only. She paid it off. He then refused to transfer. She sued.
Okay, separation. That sounds like a totally different scenario emotionally, practically. Not exactly harmonious.
Absolutely. And the court saw that difference clearly. When parties are separated, they're often negotiating, at arm's length. They're dividing assets, figuring out their future apart. In that kind of context, an agreement, especially one put in writing like this one was, looks much more like something intended to be legally binding. The seriousness, the breakdown of trust. It changes the whole feel of the arrangement.
So the state of the relationship when the deal is made is massive. Okay, what about Wakeling and Ripley? The notes mention significant sacrifices. That sounds important.
Oh, very important. Wakeling and Ripley. You had an elderly man, Mr. Ripley, living in New South Wales, Australia, needed help. He wrote to his sister and her husband, the Wakelings, back in the UK. He asked them to basically uproot their lives, move to Australia, live with him, and care for him. Now, the Wakelings told him, look, this is a huge deal for us. The husband would have to give up his job, his pension, sell their house in England. Big sacrifices. Ripley wrote back, assured them, said if they came, they'd inherit his house, most of his estate. So they did it. They moved, looked after him for a bit, then they fell out. Ripley sold the house, changed his will.
Wow. Giving up your job, pension, selling your house, moving continents, that's way beyond just doing a relative a favor, isn't it?
That's exactly what the court thought. They looked at the sheer scale of what the Wakelings gave up. Those actions, plus the letters exchanged, provided really strong objective evidence that everyone involved intended this to be a serious, legally binding arrangement. You just wouldn't make those kinds of life-changing decisions based on some vague family promise you couldn't rely on. The consequences were too serious.
Makes sense. And the materials also quickly mentioned Simpkins and Pays and pointed back to De Cruz Andrea and Guangzhou Health Products again, maybe showing other ways the presumption could be flipped depending on the facts.
That's right. There are further examples showing that while the presumption is the starting point, it's definitely not the end of the story in domestic or social agreements.
Okay, so it's becoming clear it's not just who is making the agreement, but the whole context, the relationship status, what's at stake, what people actually do. How do courts actually weigh this all up? Are they, like, mind readers trying to guess what people were secretly thinking?
Huh? No, not at all. Definitely not mind readers. The test the courts use is objective. They don't try to delve into the secret subjective thoughts of the parties. That would be impossible, right? Instead, they look at all the external evidence, the facts, the circumstances, the words used, and ask, what would a reasonable, objective bystander conclude about whether these parties intended to be legally bound?
Okay, an objective test. What sort of things, what specific evidence do the materials say the courts look at when they're doing this?
Well, they list a few key factors. Things like what was actually agreed upon. What were the circumstances surrounding the agreement like? Were they separated like in Merritt or living harmoniously like in Balfour? Also, the specific words the parties used. The likely effect of the agreement on the parties. Think about those big sacrifices in Wakeling. And importantly, how did the parties act afterwards? Did their actions suggest they thought it was a binding deal?
Got it. So you build a picture from the outside looking in. In Balfour, the context married couple, harmonious, informal allowance promise looked like a domestic thing to a reasonable observer. But in Merritt, the separation, the written note about the house, that looks much more like a binding deal about assets. And in Wakeling, those huge sacrifices just scream reliance on a serious promise.
That sums it up really well. The objective facts are the clues. The court gathers those clues and decides, based on what's reasonable in that specific situation, whether the parties cross the line into intending legal consequences. The burden is really on the person claiming a contract exists to show enough objective evidence to overcome that initial presumption.
So thinking about this objectively, for you, the law student listening, when you're analyzing a problem question with, say, a family agreement, what should you be actively looking for?
Good question. First step. Recognize the relationship. Flag the presumption against intention. Okay, but don't stop there. That's just the start. Your crucial next step is to hunt for that objective evidence that might push back against the presumption. Ask yourself, was the situation more like Balfour harmonious, informal, maybe vague? Or was it closer to Merritt separated, serious discussion, maybe something written down?
Yeah.
Were there major consequences involved for one party, like in Wakeling? Significant reliance? Did they act like it was a done deal afterwards?
Right, you're searching for those concrete factors, separation, big sacrifices, formality like writing, the seriousness of the subject matter, the things that signal to a reasonable person, hang on, this wasn't just a casual chat, this was meant to be binding.
Exactly. That objective test is your main tool for analyzing the facts and deciding if that intention element is actually satisfied.
Okay, brilliant. Let's just quickly summarize the key points from this deep dive on intention in social and domestic settings.
Sure. So number one, intention to create legal relations is essential for a contract. Can't have one without it. Number two, in social and domestic contexts, there's a starting presumption that this intention is missing. Think Balfour and Balfour. But number three,
Right.
this is just a presumption. It can be rebutted. Number four, it is rebutted if the objective evidence shows the parties actually did intend to be legally bound. Cases like Merritt and Merritt separation and Wakeling and Ripley sacrifice show this. And finally, number five, courts use an objective test. They look at the external facts, the words, the actions, the circumstances, not secret thoughts.
Perfect. And the really big takeaway for you listening, don't just see family or friends and automatically assume no contract. You have to apply that objective test, dig into the context, look for those signs of serious legal intention.
Absolutely. Context and conduct are key to potentially overcoming that initial presumption.
Definitely. Okay, now, just to leave you with something to chew on based on the material. Think about how complex modern life is becoming. You've got intricate family businesses, people living together without being married, making agreements, even friends making quite formal deals online. How might these evolving situations challenge or shape how courts apply that objective test when trying to figure out intention? Where does the line between domestic and commercial really lie today? Something to think about. Happy studying. Until the next class.